In the last video, I brought up this old rule that was in effect in Illinois prior to no-fault divorce. And that rule held that property typically followed the party in whose name it was titled after a dissolution of marriage. Now, this was not an issue that I talked about in the book, but I wanted to spend some time on it because it's one of the issues that prompted me to write the book. After I became an attorney, I did a little bit of divorce work, not a lot, and I don't do a lot now. But in some of the legal treatises that I read, they would make this claim that husbands would get more property because of this rule, right? I mean, typically men had more property titled in their name, so the assumption was that men would get more property. And I've heard attorneys say this as well. When I've complained about our divorce laws, I've heard attorneys say, well, you know, back in the day, women wouldn't get anything. As with so many of these claims, that's just not true. And as I mentioned in the last video, not only was there a principle in effect that a husband was obligated to maintain his wife financially in circumstances that were similar to what they enjoyed during the marriage, but I should also point out that there were other equitable principles as well. I've read some of these old cases, and courts could take all kinds of equitable considerations into mind when granting property in the event of a dissolution. There are a lot of cases I've read where women were granted possession of the marital home. There were cases where courts determined that the woman, by virtue of maintaining the home and participating in the marriage, that she in fact had an equitable interest in that property and thus was given a piece of that property, sometimes as much as 50%. I've read other cases where women were granted attorney's fees, again, all before no-fault divorce. And in some cases, even where the women were found to be at fault for the dissolution of the marriage. So these are the issues that prompted me to write the book. And over the course of my education and over the course of my career, I've confronted people and treatises and sources that make these claims that are either careless or perhaps in some cases deliberate or maybe a little bit of a mix of both. But this claim about property going with the party in whose name it was titled, this is just one example. I've heard other scholars and educators try to give the impression that back in the day men didn't have to pay child support because under the old common law, an illegitimate child was considered filius nullius, meaning the child of no one. But when scholars have said that, they didn't explain that there were ecclesiastical courts that imposed burdens on men. There were all kinds of legal burdens that were imposed on men, and there were all kinds of complicated doctrines, equitable doctrines, that allowed women to avoid some of the harsh consequences of the law. In the book, I try to point these issues out, and I try to give a little more detail, and I try to explain, at least point people in a direction to show that there were principles that tried to help women, and that there were other obligations that were imposed on men. So this idea that the law was imbalanced in favor of men is just simply not correct. And this issue about the titling of property is just one of many examples, and that's why I brought it up in the last video.